Hello, I'm Philip Taylor from Richmond Green Chambers. I'm talking about the Yellow Book, the Employment Court Practice. This is the current 2008 edition by two excellent authors who have produced a work with a substantial team of contributors. Swift and Chapman have produced, I think, a work which I've entitled in my written review as employing the best practice with the Yellow Book, because that's what it is. You've got everything you need, a little bit like the Green Book, the White Book, all the other books we've got. This one deals specifically with the areas of employment law. It's obviously been published for a number of reasons. As an annual court book, it's something we're going to need a lot more of clearly in the future, because it gives us a great insight into how practice can actually be dealt with in this particular publication. And it stands out as the only one in its field to offer counsel and solicitors a clear and practical insight into the workings both of the employment tribunal rules and the rule-by-rule annotations which you actually have in the book itself. The expert commentary, which I referred to earlier, obviously is broken down into particular areas by the general editors and their staff, and it covers all aspects of employment litigation at each level. Obviously it covers appeals to the higher courts, and it deals with specialist areas such as statutory dispute resolution and the limitation issue. And it's split into two parts. The first dealing with employment litigation procedure, which is of course incredibly important, and the second with issues of employment litigation practice. I think the main feature of this book, which is what brought it to my attention, because I have some practice in this area, is that it provides a new kind of court reference material for employment law practitioners. It has rule-by-rule expert annotation of the substantive law, and that gives authoritative insight, in my view, into procedural issues, and it clarifies the more complex areas, which I'm grateful for. It also gives me invaluable advice on the working of the employment tribunals themselves. We all have our own views about how the tribunals work, but certainly they give a very lucid account. And also the Employment Appeal Tribunal rules themselves. I think the annual edition, of course, is very useful because it gives a wealth of case law, which we need as well, and commentaries. Now obviously this is not really a book for any form of academic comment. It's much more a hands-on book, and both Messrs Swift and Chapman give practical guidance throughout to ensure that you find the quick answers when you're preparing a brief. It also covers the needs, all needs in fact, of our specialist areas, and there's good detail on limitation of actions and ADR, as I indicated earlier. Last year the edition had a foreword by Mr. Justice Elias, who's president of the Employment Appeal Tribunal. And they've reprinted the comments, and this is what it says. It says that the book is designed to assist litigants and their advisors through the complex maze of tribunal procedure, including the procedures dealing with appeals, and that's what it does. The emphasis is on practice and procedure throughout, and Mr. Justice Elias also talks about a myriad of intellectual puzzles. Now what they do here is those puzzles are nicely unravelled where they can be. Obviously Swift and Chapman have been able to deal with the main point which Elias referred to when he says that there are those cases which are not capable of resolution merely by the application of the overriding objective, which requires employment rules to be construed and discretions exercised in a way which ensures that cases are dealt with justly. it is obviously, it's an emotive area. It's going to be even more so with the economic downturn. So what we've got here is a practical book which gives explanations in the best possible way, and it tries to unravel these intellectual puzzles. As I've said before, there are plenty of books around. You've got a number of loose leaf works, but this one is obviously a main book, and for me it's the one that I find helpful. What the authors have done in this particular edition is they've covered the Gibbons report and explained some of the most recent leading cases up to the middle of 2008. At the end of their introduction, they make an interesting observation. They say, "Tradition has it that the Employment Tribunal was intended to be a jurisdiction free of procedural niceties and pitfalls, designed to provide prompt resolution for problems arising in the workplace." Well, if I go back 40 years over my life as a lawyer, and I think about the concept of the tribunals from the late 60s onwards, you see where we've been going, and I'm sure this yellow book will be of great assistance to people about looking at the tribunals as they stand today. It's actually going to be a white book for employment lawyers, no question in my mind, but I think we call it the yellow book because obviously it's the colour of the cover, and it can succeed, in my view, with its future aims as we go in a new direction with employment legislation. We're going to see the effect of the new Employment Act of 2008 when it comes into force later this year, which is now 2009, and we'll wait for our next established yellow book with bated breath. So thank you, Swift and Chapman. Bye bye.